Everyone. This is the fifth panel of Hess Week, our third panel today. It is good to see some of you who have been following us. It is good to see some fresh faces. We have quite a wonderful and amazing group of speakers for this afternoon's discussion on the role of the courts. My name is Gaston Alonso. I am the director of the Ethel R. Wolf Institute for the Humanities. Before we start, just 3 quick points. If you're a student, make sure if you didn't sign in on the way in, make sure you sign in on the way out. Second, a recording of this event will be housed at the Wolf Institute's YouTube channel. And third, we will leave time at the end for comments and questions pertinent to the topic of today's panel. And with that, it is my honor to introduce my colleague from the philosophy department, Anna Gotlib, who will lead us in conversation. Thank you for being here.
Hi, thank you. Can you guys all hear me? Okay, good. So I'm going to introduce our speakers in the order of they're being seated. The first to my right is Deborah Archer, is a president of the ACLU and a nationally recognized expert on civil liberties, civil rights, and racial justice. She's also the Margaret B. Hoppin Professor of Clinical Law and faculty director of the Community Equity Lab at New York University School of Law. She's an award-winning teacher and legal scholar whose articles have appeared in leading law reviews and national publications, and she's offered commentary for national and international media. Prior to full-time teaching, Archer worked as an attorney with the ACLU and the NAACP Legal Defense and Education Fund, where she litigated in the areas of voting rights, employment discrimination, education equity, and school desegregation. Archer previously served as chair of the New York City Civilian Complaint Review Board, the nation's oldest and largest police oversight agency. She's also the author of the forthcoming book, Dividing Lines: How Transportation Infrastructure Reinforces Racial Inequality, and an elected member of the American Law Institute. Archer is a graduate of Yale Law School and Smith College. All right, next we have Leah Litman, who's a professor of law at the University of Michigan Law School and co-host of the podcast Strict Scrutiny. Professor Litman also has a forthcoming book called Lawless, which I really suggest you guys go out and get once it is out. And last but not least, we have Melissa Murray. She's a 2425 Robert L. Hess Scholar-in Residence and is also the Frederick and Grace Stokes Professor of Law at NYU School of Law. She teaches constitutional law, family law, criminal law, and reproductive rights and justice. She's a co-author with Andrew Weissman of the New York Times best-selling book, The Trump Indictments, The Historic Charging Documents with Commentary. Murray's writing has appeared in a range of legal and lay publications, including the Harvard Law Review, the Yale Law Journal, and the New York Times, the Washington Post, and the Atlantic. She's a legal analyst for MSNBC and is a co-host of Strict Scrutiny, a crooked media podcast about the Supreme Court and legal culture. Murray is a graduate of Yale Law School and the University of Virginia. Following law school, she served as a judicial clerk to Justice Sonia Sotomayor, then a judge of the U.S. Court of Appeals for the Second Circuit, and Stephan Underhill of the U.S. District Court of the District of Connecticut. The way we're going to run this panel, and we do have a hard stopping time at 5 because our panelists do have to leave, is the panelists are going to each speak for a little bit about their chosen area the chosen topic. Then they're going to discuss among themselves, and at the last part of the panel, we're going to take a few questions. So let's begin.
Hi, thanks so much for all of you for being here. I know it's late in the day, and so it's great to have such an engaged audience. The topic of the panel is the role of the courts in democracy, and I will be talking a lot more about that tomorrow in the Hess lecture, so maybe this will preview some of it. But this question of what is the role of the courts in a constitutional democracy is one that has vexed legal scholars for quite a long time, simply because in our federal judiciary, judges are not elected. They're not responsive to the electorate. They are nominally brought to us by the people because the president, who is elected, can nominate judges, but ultimately the judges themselves remain insulated from the political process once they are appointed and confirmed. And so a question is sort of raised over time about what is the role of these unelected, unaccountable to the people judges in circumstances where they have the authority to review the work of the elected branches, Congress, the president, the state legislatures and governors. Should the courts be permitted to overrule or invalidate the work of the elected branches? Is there something counter-majoritarian or even anti-democratic about courts getting to weigh in on the work of those who are actually reflecting the people's desires as expressed through politics? So I will talk more about that tomorrow and how those questions continue to vex us with regard to this court. But for this panel, let me just sort of set the stage by saying, to the extent that we find ourselves in a crisis of democracy or a time in which democratic institutions seem to be stressed, maybe even failing, a large part of the blame for our circumstances might genuinely be laid at the feet of the court, the Supreme Court. And the court is obviously not a democratic institution, as I've said. It's largely outside of democratic politics because the judges are appointed for life. They are not accountable to the people in that way. But the work that they do does have a real impact on the way in which our democratic systems and institutions work. And over the last 10 years, maybe more, I think we've seen the court issuing decisions that have had a really distortive effect on the electoral landscape. We've seen the court bless the practice of partisan gerrymandering. Gerrymandering is the effort to draw legislative districts in ways that consolidate power, whether for a particular group or for a particular party. And in its 2019 decision in Russo versus Common Cause, we saw the United States Supreme Court determine that there is no role for federal courts to play in determining when partisan gerrymandering has gone too far. Therefore, the court sort of absented itself from that question and left it to the state legislatures, which are the very bodies that do much of the work of drawing gerrymandered districts. The fact of gerrymandering is one of the reasons why our politics is so distorted right now. It's one of the reasons why in a state like Wisconsin, for example, where Donald Trump lost the state. He only got 49% of the vote in Wisconsin. The other 51% went to Kamala Harris. It's a pretty evenly divided state in terms of Democrat and Republican representation. Yet, in the 8 congressional districts in Wisconsin, 6 of them are controlled by Republicans. So although the state is evenly split, the congressional delegations, which are a function of how the congressional maps are drawn, the legislative maps are drawn, are so gerrymandered that it produces Republican control in the congressional delegation and in the state legislature. So that's one way in which gerrymandering and the court's decisions blessing partisan gerrymandering have distorted our electoral landscape. Another way that the court has distorted our electoral politics is through its hobbling of the Voting Rights Act. The Voting Rights Act is landmark legislation passed in 1965 with the purpose of bringing in individuals who had previously been excluded from the political process more firmly into the process. One of the court's most recent decisions that has had really consequential impact is 2013's Shelby County versus Holder, where the court considered the fact of the VRA's preclearance regime, which required states that had a history of suppressive voting practices to make any change in their voting laws first cleared by the federal government. So if you wanted to change a law or even move a polling place in your state, if you had this history of suppressive voting practices, you had to first go to the federal government, whether that was through a 3-judge panel or the Department of Justice, and petition and explain why that change was necessary. That preclearance regime allowed the federal government to have some oversight over the states, and in so doing, it managed to catch a lot of suppressive voting practices before they went into place. In 2013, the United States Supreme Court, in a 5-4 decision written by Chief Justice John Roberts, determined that the formula for determining which states were in that preclearance regime was no longer feasible or viable. It needed to be redone. He said Congress could redo it. Congress, of course, lacked the political will to do so. Very polarized and partisan Congress did not clear that up. And so the preclearance regime essentially died. And in its wake, we've seen many states throughout the union craft increasingly suppressive voter laws, laws that make it impossible for people to do things like bring together votes and ballots from places that are far-flung, like Native American reservations, and then bring them to the local polling place. These are laws that prevent people from giving those waiting in line water or food while they are also waiting in line. They're essentially laws that make it harder for people to vote, and in so doing suppress, in many cases, minority voters who want to exercise their right to vote. So this is all to say that the court has done quite a lot to make it harder for the democratic process to actually reflect the will of the people in an accurate way, whether it's through gerrymandering, whether it's through the loosening of campaign finance laws, which allows floods of money to come into races like the Wisconsin Supreme Court race that we've been talking about all day, as well as through suppressive voter laws. And in this moment where we're thinking about how we can correct what is happening in our country, the fact of a distorted electoral landscape is a major impediment. There's so much distortion that you actually have to turn out voters in really record numbers in order to overcome those distortions, and that's a real hardship. And when the voters do turn out, when they make the calls, they do the canvassing, and they don't see their efforts translated into wins at the ballot box, then they become disenchanted with the political process, and that too is by design. It's all a way in which the harder you make it to vote, the harder you make it for the people to see their will translated into actual policies or wins at the ballot box, the more likely people are to absent themselves. And then we truly are no longer living in a democracy, and we are instead doing something else. And then the last thing I will say is that all relates to how the court's decisions affect the work of the people with relation to state legislatures, maybe even Congress. One of the court's most significant decisions was Trump versus United States, which was issued last summer in advance of the 2024 election. And I don't think there is a more corrosive decision for American democracy than one that essentially vests the president with the authority of a king to do what he likes in the scope of his official action and to draw the substance of that official action in such broad terms to basically insulate the president from any kind of accountability going forward. We are wrestling right now with what the impact of that decision will look like going forward and how it will shade the way this court thinks about the things that are actually happening right now with regard to this administration. And so this is all to say that to the extent that we have found ourselves in a state where democracy is in crisis, a lot of that can be attributed, I think, to the work of this court.
It was tough to applaud after that. We were applauding for you, not the court, of course. So I wanted to begin by thanking Professor Alonso for organizing this terrific week, and Professor Murray for providing the occasion for this. So I wanted to elaborate on something Melissa said during her remarks, but I wanted to tie it to some of Melissa's work since, of course, this is the occasion for which we are here. So in one of Melissa's pieces, Dobbs and Democracy, that she co-wrote with Kate Shaw, she described the irony in which the court in Dobbs overturned Roe versus Wade, announced that it was returning the issue of abortion to the political process, and insisted that this was democratic. That it was, good for democracy to turn this issue over to the people. But of course, the irony there is, the court had, over the last decade and more, made the democratic processes less democratic and less responsive to the people's will. And by fetishizing the state legislature at the expense of other more nuanced definitions of democracy, the court was ignoring the ways in which it had shaped the electoral system so that it was less responsive to what people wanted. And second, that the court's, again, unnuanced definition of democracy ignores the extent to which, substantive rights, in particular notions of individual dignity, are preconditions for democracy. And how the court has failed in that endeavor as well. So I am just going to touch on those 2 points. One is how the court's decisions have made the electoral landscape less responsive to people's preferences and therefore less democratic. And second, how they have taken away, individuals' dignity and thereby undermined, a precondition for democracy to even exist in the first place. So Melissa mentioned, of course, the court's famous, infamous decision in Shelby County versus Holder that dismantled a key protection of the Voting Rights Act. In the course of reaching that decision, the court announced that the pre-clearance process of Section 5 of the Voting Rights Act was no longer needed because another portion of the Voting Rights Act, Section 2, remained. That portion of the Voting Rights Act prohibits discrimination in voting on a nationwide basis. But what the court neglected to tell us in Shelby County versus Holder was that they would then proceed to weaken the protections of Section 2 after Shelby County versus Holder. So in one decision, Brnovich versus Democratic National Committee, the court upheld 2 Arizona restrictions on voting as consistent with Section 2, even though they overwhelmingly disadvantage different populations of voters of color. So in one Arizona restriction, the court discounted votes that were cast in the wrong precinct on Election Day. And that rule resulted in twice as many black voters having their votes thrown out as white voters because precincts were rapidly changing at a much higher rate in urban areas than they were in other areas in Arizona. And yet the court upheld that Arizona requirement as consistent with Section 2. The court also upheld another Arizona rule that prohibited people other than the voter or the voter's family or caregiver from returning their ballot. That restriction disproportionately negatively affected Native voters, many of whom lived on reservations or tribal lands that were pretty far from mailboxes, and therefore, they relied on other individuals to collect their ballots and return them. There, too, the court said that that restriction was consistent with Section 2. And in the course of that decision, the court basically inverted Section 2's prohibition on discrimination in voting into a protection for voter discrimination. The court announced that any restriction on voting that was widely practiced in 1982, when Section 2 was amended, was presumptively legal today, ignoring, of course, the fact that Congress, in amending and expanding the reach of Section 2, had actually tried to prohibit and eradicate voting practices that disproportionately negatively affected voters of color. I wanted to highlight Brnovich because it's a case where the court didn't strike down an act of Congress, and in so doing make the democratic process less democratic, not just by invalidating the work product of a comparatively more democratic branch of government, but also they do that by interpreting the laws that the democratic process puts out. So in Brnovich, they narrowly read Section 2's prohibition on nationwide voter discrimination to effectively create a safeguard for some amount of voter discrimination that was widely practiced in the 1980s. Melissa also mentioned the court's campaign finance decisions as ushering in a world in which political spending is overwhelmingly responsive to and dominated by a few super rich individuals. Elon Musk poured almost $300 million into the cause of electing Donald Trump in the 2024 election. And with that money, he was largely able to purchase himself a seat at the political table and give himself a vast amount of power that he is now using, to make our government less democratic in a host of other ways. And one of the worst lines and passages in the court's opinion in Citizens United was the court's insistence that massive spending by corporations, including political action committees, does not give rise to the appearance of corruption. But that statement just ignores reality, that in a world of such extensive economic inequality, when some individuals have the capacity to outspend and overwhelm everyone else's political voices, of course, that is not a system of political equality, because they are purchasing themselves outsized influence and access that other individuals just cannot get. Melissa also mentioned the court's decision in the immunity case, Trump versus United States. I wanted to give another arguably related example of another area of law where the court has made our system less democratic, and that's something known as the independent state legislature theory. The independent state legislature theory is a notion that actually emerged from the court's decision in Bush versus Gore, when the court notoriously stopped the recount in Florida and ordered Florida to certify their electoral votes for George Bush and thereby make him, the winner of the 2000 election. The independent state legislature theory is the outlandish notion that under the federal constitution, the state legislature and the state legislature alone gets to set the rules regarding federal elections. At its most extreme, that would disable state courts from enforcing state constitutional protections for voting against state legislatures when they pass restrictive voting rules. So in the court's recent independent state legislature case out of North Carolina, Moore versus Harper, the North Carolina Supreme Court had struck down the North Carolina legislature's partisan gerrymander. They were able to do that because they were a state court, not a federal court. And as Melissa noted, in Rucho, the Supreme Court said that federal courts cannot remedy partisan gerrymanders. So their decision was challenged on the ground that in that instance, that was a state court using the state constitution to set the rules regarding federal elections, rather than the state legislature doing so. The court declined to adopt an outright prohibition on state courts enforcing state constitutions in cases involving state rules regarding federal elections. But they said, we are leaving for another day the decision about how we, Supreme Court, and the rest of the federal courts will review those state court decisions and decide whether they represent the ordinary bounds of judicial review. That is, we don't think they've gone too crazy in protecting voting rights. So that decision is leaving open the possibility that when some other state court, maybe hypothetically the Wisconsin Supreme Court, given the outcome of last night's election, let's say the Wisconsin Supreme Court strikes down Wisconsin's legislative map for federal congressional representatives, the one that is so skewed that it results in a 6-2 delegation in a state that's evenly split. It's likely that that decision is going to be challenged on independent state legislature grounds. And we will be watching to see whether this is yet another instance where the court makes our electoral system less democratic. I said I wanted to mention a second point. I will just do so briefly because I know I am going long. But another important precondition for democracy is for individuals to have dignity and be able to participate equally in civic society and political life. Of course, in the court's recent decisions, in particular, they have been suggesting increasingly that equality for certain individuals, in particular for the LGBTQ community, is itself incompatible with a notion of equality for those individuals who are opposed to LGBTQ equality. And on the court's docket for this term, case they will be hearing at the end of the year, is Mahmoud versus Taylor. It's a challenge to Maryland school district's policy of providing textbooks that include LGBT individuals in the textbooks. That practice is being challenged on the ground, that it discriminates against those individuals who have religious convictions that are opposed to the existence of transgender individuals and opposed to marriage equality. That would give individuals the right to control what is being taught in our public schools and to undermine the ability of public schools to teach values like equality and to love everyone and respect everyone, no matter if they are different than you. I think that that too would be a really big blow to our democracy. I will leave it there.
All right. Hello, everyone. Thanks for coming, and thank you for inviting me and including me. I have known Melissa for a very, very long time, long days, and so it's wonderful to be here to celebrate her. But it's also wonderful to join these two very fancy constitutional law scholars. And so I don't want to try to compete with them in their space. They are brilliant in discussing constitutional law. And I'm going to take it in a different direction and talk about, I guess, the larger ecosystem that the courts operate within. because although we put a lot of emphasis on the role of courts in protecting our democracy, and we absolutely should, they play a critical role, they are just one piece in this larger ecosystem that comes together to defend our rights, to define equality, to enforce equality, to stand up for justice. And for people who fight for justice and equality, we have always known that securing a legal ruling or getting legislation was just one first step. That the real work comes afterwards when you try to enforce that legal ruling, when you try to give life and meaning to the legislation and help that legislation connect to the lived realities on the ground. And those on the other side who would fight against equality, who want to tear down all of the means through which we achieve justice and equity, they understand that tearing down or overturning one legal ruling is not enough to change reality, that they have to go at that broader infrastructure, that broader ecosystem that helps, that those of us who have been fighting for equality have been fighting for to build. They know that if they want to see the change in this world that they believe should happen, that they have to tear down that larger ecosystem. And so, we've been talking about a lot about the Voting Rights Act, and that's one example. The Voting Rights Act was passed, and it can declare that everyone has the right to vote. But it was the work of advocates and community members and voters standing up and demanding their right to vote and fighting to give meaning every day to the Voting Rights Act that resulted in us having elections where record numbers of people of color and other marginalized folks participated. I hope some people in this room know who Charles Hamilton Houston is, but in case you don't, Charles Hamilton Houston was Dean of Howard Law School, General Counsel of the NAACP, and one of the legal architects of Brown versus Board of Education. And he often talked about the groundwork that was necessary to kind of fortify and amplify the work that he was doing in the legal sphere, that it wasn't going to be enough for him to do the work to get the Supreme Court to declare that separate could never be equal. There was so much work that had to go around that to support that decision, to support that work, and then to give that decision wings. And so pieces of that are important to highlight. One is kind of a governmental infrastructure around enforcement. You can't have every individual who has their rights violated is not going to go to court to enforce that right. They don't have the resources. They don't have the time. They don't have the knowledge to be able to go forward and do that. So it was important in the years after Brown versus Board of Education was decided for us to have a Department of Education that developed to enforce that right, to go around. You could bring your complaints to them. They could identify violations of rights within the educational context and make change. You didn't require an individual to come forward and file litigation. Melissa was talking about the Voting Rights Act in Section 5. Section 2 is there so that individuals or groups could file litigation and challenge inequitable voting practices. But Section 5 was there so the government could get out in front of it. They could do the work to enforce our rights. And so we've seen that being torn down as we see the Equal Employment Opportunity Commission, the DOE, Department of Justice, all of those agencies that are important parts of the infrastructure aren't there anymore to continue to give meaning to our legal rights. Another important part of that infrastructure is a system of attorneys on the ground. At the NAACP, and when I worked at the NAACP Legal Defense Fund, they called them cooperating attorneys, this network of attorneys throughout the South that would bring these cases and help them get into courts and get into the Supreme Court to really give meaning to the decision in Brown versus Board of Education, to give meaning to decisions around the Voting Rights Act, to give meaning to decisions around Title VII of the Civil Rights Act that focuses on access to equal employment opportunity. And again, we can see that infrastructure of attorneys that can come to the defense of individuals and communities is under attack. Law firms that have done cases that are disfavored, attacks on legal education, ways that we are making it far more difficult for people to be willing to step forward to take on these cases without fear of repercussion. Another important piece are powerful communities that can come together to defend their families and their neighbors. We are making it more difficult for people to be able to step forward, to take the actions to defend themselves, to defend the people they love, and to defend the people around them. We're making it harder for those folks to stand up and speak truth to power, right? The right to protest, the right to seek redress from your government, all those things are being threatened and are important, critically important, in enforcing and building and fortifying those legal victories that we see in the court. And then importantly, we're seeing attacks on the freedom of the press and the ability to tell stories. Freedom of the press is important because we want people who can investigate the facts, share the facts on the ground, and then tell those stories of people who don't have platforms to tell their own stories. We're seeing attacks on celebrating Black History Month. And that may seem trivial in the grand scheme of things, but it's important for us to be able to tell the stories that give people hope and the stories that provide a roadmap for how we can do the same thing that those who came before us did. So I think it's important for us to understand absolutely the central importance of our court system in defending our democracy and the legal rulings and legislation that all come out of that. But it's also important to understand that it's just one tool and that lawyers are able to exercise that legal tool, but every other person in our communities, everyone in this room, lawyer or not, is able to be a part of that infrastructure that stands up for and defends our democracy. And then the last thing that I'll mention before we get into discussion that I think is important to recognize now is how we define victories in the court. Both Leah and Melissa were talking about some really depressing things that have been coming out of our courts lately. And moving forward, you may hear about what's going on in our courts and think that it's all bad news. It's all losses, because we have a really narrow definition of what victory looks like. In this country, is either you're winning or you're losing. In court, they either ruled in your favor or they didn't. And that's not really how we have to measure victory, how we should measure victories in the days and weeks and years ahead. Victory may look like minimizing harm. When we were in the first Trump administration and there was family separation, part of the victory was that we were able to make it less awful. When there was the Muslim ban, narrowing it, fewer people were harmed. That can be victory as well. It is not the sweeping grand victory that we would hope for, but we have helped some, helped more than would have been helped otherwise. Victory may be seen as delay, that if we can put off a bad ruling for a week, for a month, for a year, that's a victory in and of itself as well. In the days following the Dobbs decision, a lot of work was being done using state constitutions to try to hold on to the right to access reproductive health care in states around the country. And that was important, even if the people thought that ultimately the Supreme Court, someone else might strike that down. For 1 week, while that litigation was ongoing, during that week, people were able to access their right to reproductive health care and access to abortion care. And that was important for those people. It was important when we were fighting challenges to affirmative action, that in the meantime, that those programs that help open the doors to opportunity in a system that is designed to amplify inequality, it's important that we have kept that door open for the month or the year or weeks, because it's more students, more kids who have access to really transformational educational opportunities. So as we're watching the news and seeing what's going on in the courts, don't just think about whether or not we won or lost at the end of the day. Think about the ways that case, and has gone through the system, has been able to protect more people, provide opportunity for more people, save more people, and some of the things that Leah was talking about in the bans on care for transgender kids. So that's about saving lives. And the longer that we can keep access to that life-saving medical care and support, it's going to save children's lives. And so let's not give up the fight in the courts because we think we're not going to win at the end of the day, because if we've delayed it for a day, we have won. So I'll leave it there and look forward to questions.
All right, thank you. So I have a question. Would you prefer to talk amongst yourself about a particular topic that you find that you share, or would you like to go to questions? What would you like to do? Okay. Well, I'm going to take the moderator's prerogative and ask the first question, and this goes to all of you. So, I mean, we have a room full of students here, mostly, and I teach students in a course called Philosophy of Law. And a lot of the questions that come up is they will see on the news a student being arrested, deported, sometimes shipped out of the country for simply, not for committing a crime, but for simply saying something which the government disagrees or does not like to hear. The students hear about their grandparents and their parents' fear of Social Security being lost and taken away, what they're going to do. And then they ask, so where are the courts? And I guess my question is, well, the courts can place injunctions. The courts can temporarily stop, but the courts don't have armies. The courts don't have that kind of enforcement. So where are we in this situation where the government is beginning to act like an autocratic state, and the courts are still sort of located in a space of democracy? They're sort of ruling as if we're still in a democratic republic. So where do you think that's going to come out? I know it's a very open-ended question, but I get these questions a lot from my students.
It's not just open-ended. It is like the question, and we're all like, that's the one question we didn't want, but I'm going to...
I guess I am being called on to answer the question. So where are the courts? I guess I am going to try to take Deborah's cue in thinking about what victory looks like these days. And so I would say, where are the courts? There are some lower courts who are doing important things that are temporarily halting at least some of the more horrifying repercussions of what you identified, Anna. So in particular, in the cases involving students being arrested, whisked off the street, not for committing a crime, but because they are involved in student activism that the administration does not like, courts have immediately issued orders preventing the federal government from removing those individuals from the country before courts have the opportunity to assess their claims. That in itself is significant because in a world where the administration immediately removes and deports, if not summarily expels people, not to their country of origin, but to some horrific foreign prison in El Salvador, then at that point, there might not be anything the courts could do to wind it back. Because once an individual is in the custody of a foreign state, like in the El Salvadorian prison, a district court in the United States does not have jurisdiction or authority over the president of El Salvador to order him to put those individuals on a plane back to the United States. That is part of what is so horrifying about what we are seeing now with the administration's initial, renditions, kidnapping of individuals to El Salvador. And so, again, thinking about what a victory looks like here, right, like at least those individuals are still in the country, even if they are being wrongfully detained when they should not be. I am hoping there will be some decisions, right, taking seriously the underlying First Amendment claims and being willing to review the Secretary of State's, obviously pretextual determination that the presence of these individuals has adverse consequences on our foreign policy. And so, at a minimum, we are preserving some judicial review, some due process, at least for those individuals, and that is something, even though it is gutting, what is happening. And I could say something similar about, the dismantling of the administrative state. There have been several important decisions from district courts ordering the administration to rehire, the thousands of employees they just all of a sudden terminated, or to order the administration to keep the functions of the Consumer Financial Protection Bureau in operation. That allows those agencies and those federal employees to do their important work for some period of time. And that itself, right, is something that is better than nothing. And so I think it is important to recognize that this is happening, in part because the attacks on the lower court judges who are engaged in these rulings, right, is a threat to the minimal amount that is happening. And so taking the opportunity to say, these are judges who are doing their jobs, they're doing it well, like, we stand with them to participate in that democratic ecosystem, to uphold the rule of law, is, I think, something that is still worth doing, even though, of course, I wish there was more happening.
I just want to quickly add that I'm not sure that we're at the point yet. We're close. Every day we get closer to the point where we should feel some panic. But there are lots of cases going on, lots of challenges to the things that you're seeing. I think they don't get as much attention as they should. So people need to know that there's a resistance, what it looks like, and what's going on. But I think largely the administration's response has been to deal with the challenges in court and work their way through the legal system. So, appealing within the court system. We have to separate the kind of rhetoric that's happening in social media and outside of the courtrooms from what's actually going on inside of the courtroom. So right now, for today, I think that we're at a point where it is moving its way through the court system, and people should have some faith in that. All of the judges in our federal court system, they have sworn to uphold the Constitution and the laws of the United States, not to be loyal to a particular president. And I believe that those judges and justices will stay true to their oath. And if they don't, or if we get to a point where the administration is not following the rule of law, then there'll be other tools that are available to us. But at the end of the day, it may come down to, as I was saying, we're working our way through the court system, but you also have voices that you can lift up, and making sure that your voices are heard. It's at a point where Congress may need to step in and do their job as well. So we can't put it all on the court system, but the court system is, people are utilizing it and trying.
Okay, thank you. So let's have some questions from the audience now. If you raise your hand, the mic will come to you.
Hi, thank you so much. I really appreciate everyone here on the panel, as well as mentioning the resistance, because I think last panel there was a question about is this it? Because I know that for a lot of you that are lawyers, this is your profession and that's all that you know that could help. But I know some people think about, going to the streets and taking to the streets. So my question is, I know as a leftist, or maybe you're a moderate, if you like to stay within the line, I know we like to say within the lines of this is what the law says, we have to do it the right way. And then you have this guy in office basically saying, doing whatever he wants, and then people are like, can he actually do that? And you're like, as a lawyer, he can't do that, but he is. So you as a lawyer, and you're with your experience, do you feel like within our community there is this ideal of doing the quote unquote right thing, and does part of you sometimes have the urge to kind of step outside of that and kind of it's not fair. It's not fair. So what parts of you, how does that manifest into action, whether it's activism or whether it's okay, maybe I'll slip in, it's off, well, we're recording, but off book, maybe I'll slip in this on the docket when I'm not supposed to, or have this outside conversation. All right, let's keep it.
So the question, I guess, is, are we getting punked? And what are we doing about it if we are? So I'll say this. What is happening right now is being presented as though an overwhelming majority of the public and the electorate supports it. And I think one of the things that we at least try to do on our podcast and the way we talk about these things is to make clear, like, this mandate does not exist, or at least not in with the force that it is portrayed, right? So this was a very close election in which a large portion of the electorate did not participate. And it is also an election in which a large portion of the electorate who did participate seemed to be driven by bread and butter pocketbook issues, not necessarily issues like the rendition of lawful green card holders to other countries. So to say that what is happening right now is happening with the support of an overwhelming majority of the electorate is false. Like, full stop. That is false. And I think one of the ways we have to combat what is happening, like whether there is someone in office who isn't playing by the rules, is to explain over and over again that not all of us signed up for you not playing by the rules. In fact, maybe a majority, maybe even an overwhelming majority of us did not sign up for you to not play by the rules. And it goes back to what Deborah said. We can do our work as lawyers, which largely involves filing papers and showing up in court, but that's not the only avenues that people have for expressing their displeasure, if there is displeasure, with what is going on. There are other things you can do. If you are concerned right now that Congress seems to be asleep at the wheel, I share that. There are things you can do. If you liked what Cory Booker did last night, call your congressman and say, like, why aren't you doing that? I would like to see that from you. If you object to the way that your senator responded to a particular issue, like the debt ceiling or whatever, and you want to express your views, there's an avenue still for you to do that. Like, this is the thing that I can't emphasize enough. There are still avenues there. They haven't closed off those avenues for expressing your views. And we should use those, because if we don't, they're going to assume that we don't care, that this is condemnation, and that they have a mandate to continue doing it. And so I don't know if we've gotten punked because we like to push paper and we like to do things by the rules. I think most people generally try to do things by the rules. But when you're faced with people who don't do things by the rules, I think you have to keep doing what you're doing, but also do more. I mean, I think of this like, how do you parent toddlers, right? Like, I've done two now. I don't know how successfully I've done it, but toddlers are not people who care about your rules. That doesn't mean you abandon the rules entirely, but you do supplement with other things. And sometimes that's enough. Like, it gets you over the hump. And I think right now, Deborah is right. We may not be looking at unalloyed victories, but we may be looking at keeping the door open for a little bit longer. And that has to count as a victory too. So I think right now, for a lot of people, the goal in sight is simply getting to 2026. Getting to the next election where maybe you get control of the House, maybe you get control of the Senate. But how do you keep the door open long enough so that this doesn't spiral completely out of control? That, I think, is partly law, but it's also partly everyone else.
Yeah, so I guess I wanted to say two additional points on that. One is, I don't think these things are mutually exclusive. I think that, for example, like in the litigation, that is happening, you have people who are articulating claims that resonate like with the broader public. So, for example, like when I'm talking about Citizens United and like ushering in, right, like all of this vast spending and why I think that's like a wrong interpretation of the Constitution, right, I think that is related to some of the like Tesla takedown protests and the calls for no kings. And so when I am explaining and trying to explain more, like this is all wildly illegal, right? It is providing a basis and like my hope to like reinforce more public facing calls, right, for like elected Democratic representatives, for courts, right, and like other individuals and institutions to stand up as well. Like, I don't view these things as mutually exclusive. And with an eye toward like getting to 2026, like the litigation also slows things down, right? Like any act of resistance that creates friction is helpful, right, in slowing our descent into autocracy. And so, like, if these cases, right, are diverting resources away from them, right, like sending out federal government lawyers, right, to like try to find more students to deport, like, that's a win in my book.
And I'll just add one point in response to something you said, that what we were doing was inside the lines, and then the other stuff is outside the lines. The other stuff is in the lines too, right? Protest is legal. Protest is a legitimate form of engagement, and I think we're in an environment now where people feel like those things are forbidden. Certainly, there are some of us who might be at higher risk if we engage in protest, and you should be aware of that and act accordingly. But protest is absolutely a viable tool. Calling your representatives, speaking out, absolutely an appropriate tool. What we're seeing is all of this disorganized chaos. And the best response to the disorganized chaos is organized resistance. And that is what we have to do. Be organized. You know, the legal community is organized in trying to fight within in the court system. Folks have to get organized in their communities. How are they engaging in protests? How are they speaking out? Are they doing Know Your Rights trainings for people in communities? Are they having phone banking for people to call elected representatives? Are they writing letters? Are they engaged at the state and local level? We're so very focused on what's going on in the federal level, but states have a lot of ability to defend their citizens, to fight back. So are you also pushing your state to use everything that they have at their disposal to defend us and to defend our rights? And so I think people absolutely have to get organized and not rely on us.
Other questions?
Hello. So, background about me, I am studying to be a middle or high school social studies teacher. Thank you. You might also notice I'm transgender, so, you know, masochist. But my question isn't related to that. So I view what my work is as kind of the long con, building the foundation. And you all do your wonderful work where you engage a lot with the public, with students. And as I'm teaching, I would love to know, to be able to integrate it into my teaching practice, what are some of the most powerful misconceptions about the courts that you have heard that undermine democracy?
So I can start with two. One is that, at least when I was in school, I feel like what I learned about the courts was a story that went, first there was Plessy versus Ferguson, and then there was Brown versus Board of Education. And these things just happened magically because the court recognized the error of its ways. Whoa, no, right, like very important to understand everything that is happening outside of the courts that made it possible for the court to issue its decision in Brown. Second is that limited data set gives a woefully inadequate picture of the Supreme Court's role in our constitutional democracy over time. Because the decisions, again, that I learned about, you know, up until basically law school were all Warren Court decisions. The Warren Court is the court that is led by Chief Justice Earl Warren. It's like the most progressive court in United States history. It's a very atypical court if you look at the court's broader history. And so I think teaching people more about like what the court was doing before the Warren Court, what the court has done after the Warren Court. I think some people think that the court as it is today is atypical, and I do think it is like uniquely bad in particular ways. It is more isolated, right, from the majority of the country, and therefore it is doing some like extra wild things. But I do think like this is not the first court to make our constitutional system less democratic. And so understanding that the court has not been on the forefront of protecting those groups who are actually voiceless in the political process or society is, I think, an important corrective. So when people are thinking about big questions about what should the court's role in our democracy be, like they understand how the institution has actually functioned.
I agree completely with what Leah said. I'd actually go further. I don't even know that we should credit the Warren Court with being this overwhelmingly progressive court. Justin Driver has this wonderful article in the California Law Review from, I don't know, probably 10 years ago called The Conservatism of the Warren Court, where, he talks about, like, they did some great things. They also had some missteps. It actually is left to the Berger Court, which followed the Warren Court, to read women into the 14th Amendment. The Warren Court is actually kind of terrible on gender equality. So all to say that we live with this narrative in which the federal courts and the Supreme Court in particular function as white knights vindicating the rights of minorities, when in fact, for most of our history, the court has actually been a really regressive institution, doing the absolute most to stick it to the absolute most people. So that's one thing that I think is a misconception. The other misconception is that we talk about the court and the courts as though we're only talking about federal courts when those are not the only courts that exist. And in fact, state courts have actually been more progressive in some domains than federal courts have been, in large part because state constitutions are often more generative of individual rights than the federal constitution is. So, for example, in California in 1948, in a case called Mendez versus Westminster School System, the California Supreme Court struck down segregation in public education well before Brown versus Board of Education. Likewise, in a case called Perez versus Sharp, also in the California Supreme Court, California invalidated bans on interracial marriage well before the court did so in Loving versus Virginia in 1967. So to talk about the courts or the court should not limit our imaginations to just the federal court and the Supreme Court.
And I plus one on all of that, and I will just add one more, and it's that we often talk about the law as if it's neutral, that it is, here's the law, and it's, applies equally and wonderfully to all of us, when in fact there's inequality baked into the laws. And we talk about judges as if they're neutral, when in fact everyone brings their lived experience to what they do as judges, and we need to be aware of that and talk about and explore how that impacts how they apply the law and their rulings.
Can I plug you for a minute?
Sure, please.
Deborah has a wonderful book coming out on April 15th called Dividing Lines, and it's all about transportation and justice. And one of the things she notes is that in the period following Brown versus Board of Education in 1954, when the South was in open rebellion and refusing to desegregate or refusing to integrate its schools, they also began doing things like instituting interstate highway policies, like citing interstate highways, and they did so in ways that allowed them to actually physically segregate, even as segregation was slowly dying out as a legal matter. And so this isn't confined to the South. Robert Moses was one of the architects of this kind of transportation and justice, and a lot of the work that he did was right here in our backyards in New York City. So every time you're on the BQE, transportation and justice in action. And Deborah's book is fantastic.
Thank you.
My question is to all three of you. First of all, highlighting that despite holding prestigious positions, you do not abandon a largely working class institution and choose to, take your time. Of course, leave it to deliberate, intentional, educated women to not abandon working class students. But you talked a lot about little victories and about how if we can stave off fascism for one more day, that would be a victory. But for me and a lot of my peers, that's not enough. It's not enough that Mahmoud Khalil is not free. It's not enough that Cory Booker, while, a sensational action, did not mention the Palestinian resistance once and is a man that still takes corporate PAC money, as well as, many of his bipartisan peers. My question is about hope, because this country is lacking. It's lacking in community. It's lacking in outreach. As we descend into what feels like an attack upon expression, separation between church and state, things like Roe versus Wade, and now like what feels like an all-out class war that we have no chips in. I ask what we can do outside of the courts to make things in the courts more possible. And you talk about avenues, but those things have lost their, I won't say utility, but definitely our hope in those systems has waned. And as students, where we have to choose one day how long we're going to decide to rent for, rather than if we're going to be able to buy a home, or we have to choose between rent and groceries on a pretty large scale as the working class. How do you recommend we facilitate hope amongst our peers? Thank you.
Oh, okay. Oh, all right.
I feel like I've been going for it. I feel like I've been monopolizing.
Yeah, we're looking. You said so much, and so the responses may seem a little disjointed, but I just want to kind of try to hit some of the points. When you said that one more day is not enough, I don't disagree. And so when we go into court, when we try to push, the ACLU is one of the folks representing Mahmoud Khalil. One more day is not the goal, but recognizing the value in the resistance and those who will be able to enjoy their rights for one more day, I think is important. Because for me, hope is about just celebrating victories, celebrating the wins, because otherwise you lose hope. If we're so only focused on what we've lost, not on what we have and not on what we're keeping and what we're fighting for, then I think it's easier to lose hope. And so for me, focusing on absolutely the long-term goal, but also recognizing the small victories along the way is important. And so I work with students. We represent people who are unable to afford legal counsel, and I celebrate all the wins. If they win one small motion, if they are able to have a successful negotiation call, all that's reason to celebrate to me, because there's so much despair all around us. And so it's not enough. I think we need people who are speaking and working at different registers, and people who are speaking and working in different time frames. If you're a lawyer, I think to a certain extent you believe in gradual change, you believe in the value of gradual change. Lawyers tend not to be the most radical and transformational folks in the bunch. But it doesn't mean there's not space for radical and transformational change, for people to be fighting for that. One of my colleagues at NYU, Daniel Harawa, has an article called In the Shadow of Suffering. And it is about trying to weave together the threads of abolition and systemic reform, and people who are working in the middle trying to minimize harm. So for him, it's all suffering in the criminal legal system. People are suffering. And there certainly needs to be a group of folks who are fighting for abolition, who are envisioning a whole new system, who want to say this is how we can replace this harmful, destructive system with a brand new system where everyone in it will be treated with respect and be able to live with dignity. But that's a long-term goal. That abolitionist horizon is decades, if not longer. In the meantime, there are people in the current system suffering. And so there also needs to be people who are fighting to defend the people in that system, to end their suffering, to get them to a better place. And there also needs to be people who are trying to minimize the number of people who are caught up in the system and suffering. None of those people can claim that they have the one right thing, that they're doing it the one right way. All the ways that they are engaged in that fight is important. So I think someone like you who really feels the pain and understands how larger systems are harmful or no longer working in the way that they should. We need folks like you who are creative and impatient and want to fight for change and demand it now. At the same time, you need other folks who may be like me, and I don't want to quote Dune, but I'm going to quote the movie Dune, like our plans are measured in centuries. We sometimes need to plan long term. A lot of what we're seeing now is the result of decades of planning. And so we also need to plan for decades. Like the Roe versus Wade, they started to tear that down in 1972. That's when it was, right? 73. The minute it was decided, they started to chip away at it. It was death by 1,000 cuts. And so restoring the right to access abortion care is not going to happen overnight either. We have to rebuild. And so I think we need people who are thinking on the long-term horizon. This is our goal. And here's the 20-year plan. Here's a 10-year plan. Here's a 5-year plan. And here's what we need to do right now to minimize the suffering in that system. So I really do hope that you will do the work to envision new systems, to envision ways that we can exist as a society better, more justly, fairer than we are now, and that you'll do the work to do that. I have an amazing mentor who tells me all the time and reminds me on days where, and he's reminding me a lot lately because these days have been rough, that we're all sitting in the shade of trees we did not plant and drinking from wells we did not dig. So for me, what I got to do every day is get up and plant trees and dig wells. And I may not ever see the benefit of those trees that I'm planting or drink the water from those wells that I'm digging, but I know that maybe my kids will, or my children's children will, or you may benefit in a way that I have not. But it doesn't mean that I won't. I have to still do that work. And so, again, different registers: long-term, short-term, transformational, incremental. It's all important and it's all necessary.
I think one of the most profound failures in our society was that we did not take the Occupy Wall Street movement seriously in 2010 to 2011. A lot of the infrastructure for that, I think, has been repurposed into other things, Black Lives Matter and other kinds of movement organizing, but the failure to address the central conceit of the Occupy movement, which was profound and increasing income inequality among various sectors of our society, was something that needed attention and just did not get the attention that it deserved. And I think it's one of the reasons why we are seeing we have the system we have right now, where we are essentially fighting against what is an oligarchy. And it is one that keeps a lot of us out. And I think the roots of that were in 2010 and 2011 and the failure to sort of understand how far-reaching the consequences of income inequality were and would be. Income inequality, I think, is something that gives people, as you've said, reason to lose hope. If there's such disparity in wealth that you can't even imagine the prospect of home ownership, and that's sort of a hallmark of what it means to be an American, yes, of course, this is going to drive down the desire, the hope. It's going to beat people down over time. But what it also does is it divides us. And I don't mean divides us from the oligarchs. I'm not including myself in the oligarchs here. But when we are talking in this last election about the price of eggs, the price of milk, the failure to be able to purchase a home, the scapegoats often became other people from other places who were coming in and draining resources that otherwise could have been used to address those questions of basic inequality for quote unquote real Americans. And that's by design. That is by design. Take your eye off the billionaire and instead look at the person who's undocumented that's taking what's yours. And it worked for a large portion of the electorate. So one of the things we have to reckon with is, yes, it is a massive problem, income inequality. It is a massive problem that students, in order to move through the social classes have to take on massive amounts of debt. It is a real problem that we don't have a basic structure to provide quality education at an affordable rate the way other civilized democracies do. But it can't be that the answer is because of these other people who we have now demonized in our quest to manifest our own dissatisfaction with our situation. And so that, I think, also contributes to hopelessness, the way that we have failed to find common cause with these other people who are just as invested and brought down by the inequality that we are complaining of.
So I just wanted to say like a few quick things. One is that like one day is obviously not enough, right? And the fact that individuals like are arrested and detained but still in the country is obviously not enough. I think the way I think about acknowledging those as like avoiding more harm is a way of sustaining myself so I can stay in the fight like the way I am in that fight. But that's not to say that like the way I am in that fight is the way everyone else has to be, nor is it to say that like what sustains me, right, should sustain everyone else or anyone else, right? Like I took heart from Wisconsin, I took heart from like Booker's stand, not because they are perfect, right, but because they are something and they are enough, right, to give me some energy to keep fighting. On the like what to do, I think the difference between like a 5-year plan, a 5-day plan, and like a 50-year plan is super important, because like one thing I am not doing right now is picking up on what Melissa said, is like reimagining a kind of messaging that would allow us to talk about economic inequality in a way that isn't scapegoating, right, or victim blaming, right? Like if your forte, right, like your strength is like communication, right, then like that would be something that like focusing on, right, to give hope might, might be it. Other people are going to be great at like thinking about building institutions, because our institutions right now, like looking elsewhere, like they're not going to save us, right? Like Congress isn't saving us, courts aren't saving us, et cetera, et cetera. And so reimagining what functional institutions, representative institutions, egalitarian institutions would look like when we reemerge from this wreckage, because we're not just going to be able to go back, right? Like they have hollowed out the administrative state, and the way things were is what got us to where we are now. Things need to be different. I don't know exactly what it should look like on the other side, but like I know people need to be thinking about that, and I want to hear about it. We also need to be investing in new leaders, right? Because our leaders are not meeting the moment. And so one thing that gave me hope is like this morning, State Senator Mallory McMorrow like announced a campaign for Michigan Senate. She is, the individual who was unhoused immediately after college, who went viral when someone called her a groomer, and she stood up for trans kids and the LGBTQ community. And, so that is something. Also, if you are interested in thinking about like how do we change specific parts of our infrastructure that got us to where we are, I want to recommend Elie Mystal's book, Bad Law. It goes through 10 popular laws that are actually ruining America, things you might not have heard about and that aren't on people's radars as things to fix about our current system. So I think there is so much to be done that will have longer-term benefits by way of messaging, imagination, finding new leaders, community building, that those might be avenues for hope and things to do.
So we've unfortunately come to the end of our panel. We're going to end this on a note of hope. I just want to mention a law school mentor of mine after the first Trump election told me two things. He said, there's short-term hope and there's long-term hope. And sometimes you need one to fuel the other. And let's thank our speakers.
I can have just 1 minute. But what I really originally was going to say was I wanted to remind you tomorrow at 11, right here, Professor Mary will give the Hess Memorial Lecture. And then tomorrow at 2:15 at the William Jefferson's room in Subo, we have a special treat. We have the three co-hosts from Strict Scrutiny will be there, as well as Maria Hinojosa from Latino USA, and in the mix, as well as Eric Marcus from Making Gay History. Having said that, I'm so proud today. As a product of public education, I am so proud of my students today. So thank you.